Good evening. Happy Tuesday. I have a lozenge in my mouth because my throat decided to get a little sore today. So if you hear it clicking around or if it sounds like I've got something in my mouth, it's because I do. I've gotten some pushback from Lane Myers fans, and enough pushback that I think it would be worth addressing some of it. He says Lane Myers has completely dismantled the premise that a citizen cannot even be held in contempt on that particular day. And he hasn't, for the same reason that if you speed past a police officer and you don't get a ticket, if he doesn't pull you over, that doesn't mean the police officer can't pull you over and give you a ticket. It just means that the officer has exercised his discretion in not doing it. It's my firm belief that the judge in the case that I was reviewing in the Lane Myers flirts with contempt video, the judge exercised her discretion to not find Lane Myers in contempt. Why she did that, I don't know. Could she have? I believe she could have. He says he must receive due process, go through evidentiary hearings, have a jury trial, and then be held in contempt. Well, let's deal with this. This is the New Mexico Rules of Criminal Procedure for a magistrate court. I think he was in a magistrate court or a municipal court. I'm not sure which. Doesn't really matter. Same basic rules for each. The first thing is the summarily. So a direct criminal contempt may be punished summarily at the time of contempt, summarily at the time of contempt, without further evidentiary proceedings. No jury trial, no evidentiary proceedings, a direct criminal contempt. So just so that you understand what those words mean, because in law, words do have meanings. Contempt is like disorderly conduct, insolent behavior, anything that obstructs or hinders the administration of justice, misconduct of court officers in official transactions, that would be like attorneys, disobedience of any lawful order, rule, or process of court. Direct contempt means it happens in the immediate presence of the judge and is personally observed by the judge. So, violating a court order outside of the courtroom, indirect contempt. Violating a order of the court in front of the judge, where the judge sees you violate the order, that's direct contempt. Indirect contempt means it's outside of the presence of the judge or not personally observed by the judge, and therefore requires further fact finding. So, direct criminal contempt. Oh, yeah. And the difference between criminal contempt and civil contempt is intended to pressure you to comply with a court order. So if you're not producing evidence that you've been required to, the court might find you to be in civil contempt and might say that you have to remain in jail until you produce the evidence. Things like that. Civil contempt is often used for failing to pay child support. The court will hold you and will jail you or do something like issue a monetary fine each day that you fail to pay the back child support. Criminal contempt is just you did a bad thing and you're going to get a spanking now. So that's criminal contempt. It's you've already done the bad thing. It's not like you could undo it. It's not like you could produce the document that the court had ordered you to produce or whatever. You've already disrupted the court hearing. That's criminal contempt. It's a punishment. So it can be punished summarily at the time of contempt without further evidentiary proceedings, except in cases of flagrant contemptuous conduct, which means ignore the next sentence if it's flagrant contemptuous conduct. But except in cases of flagrant contemptuous conduct, before summarily punishing, again, that word summarily is important. Before summarily punishing a person for direct criminal contempt, the judge shall give the person a warning, either orally or in writing, to no longer engage in the contemptuous behavior, and shall give the person an opportunity to explain the conduct. Now, I've seen some New Mexico cases where basically it says, well, if you punish them first, well, technically, but you could still, it's still a valid order. And where the court gave warning, and then gave a final warning and said, if you interrupt the court again, I'm going to find you in contempt. They broke for lunch, came back from lunch, the court found him in contempt, and he hadn't violated that last warning. Well, even in that case, the Court of Appeals found that it was a valid finding of contempt. So when the judge summarily punishes a contempt defendant for direct criminal contempt, the judge shall forthwith sign and file with the clerk a written order which shall constitute a judgment and sentence certifying the specific facts constituting direct criminal contempt. A lot of this is for the municipal and magistrate courts is due to the fact that if it gets appealed, you get a de novo trial. So you actually get a full trial, no jury, but a full trial. The judge personally observed the contemptuous conduct committed in the presence of the judge without any further fact finding. The punishment was summarily imposed, and the court has not imposed any term of imprisonment that exceeds 6 months. And then there's indirect, which we're not worried about. In the appeal, any person found guilty of criminal contempt may appeal, and it goes to the district court from the municipal or magistrate court. So this particular rule cites heavily from Concha versus Sanchez, this case right here on the screen right now, a New Mexico Supreme Court case from 2011 that really goes through and discusses contempt, like civil contempts, criminal contempts, disruptive or defiant conduct. When the judge is not personally witnessed, it's indirect. The contempt power of the court is so broad that it's uniquely liable to abuse. So this is a really good discussion. This case is a really good discussion on contempt. So that's why I left it in here. Now, contempt is still valid. This is the United States Supreme Court case from 2023. This is the most recent one on Google Scholar for direct contempt out of New Mexico. And in this particular case, Marshall is a attorney who's been suspended, so he's no longer a licensed attorney. And this is at a hearing for a disciplinary hearing in front of the Supreme Court. Attorneys are generally, varies on the state, but generally speaking, the Supreme Court of a state has the ability to make rules for attorneys and discipline attorneys. And in this case, he was at a hearing for his discipline. He had an attorney with him, but he wanted to represent himself, which is fine, but the court required him to be sworn in. Marshall made two real blunders. Number one, he argued, and he kept arguing without swearing in. And I see here where the judge says, so if you want to say anything else to the court right now, anything at all, it needs to be done under oath. He's not consenting to be under oath, and also he keeps interrupting and talking over. So there's a lot of interruptions, a lot of attempts at interruptions, and based on that, the court found him in contempt. The court held Marshall in contempt of court both for the rule violations alleged by disciplinary counsel and for his behavior before the court during the show cause hearing. That's what this excerpt from here is, from the show cause hearing. And he got found to be in contempt of court. They fined him $2,000 for just talking, interrupting the court and talking. And again, there was no evidentiary hearing, no jury trial, so sorry. In fact, on this one, I think it says that there is no right to a jury trial. And here we go. Under New Mexico SA, I don't know what that stands for, but it's section 35-8-1. A criminal contempt defendant in magistrate court is not entitled to a jury trial, and because of that, the maximum sentence is 6 months. So is not entitled to a jury trial. So this whole thing, I mean, no right to a jury trial. So there you go. Get with an attorney. You are misinformed. Wow, I feel so misinformed. He says, by the way, he gets away with it all the time because words cannot be contempt, and he knows it's an idle threat from a tyrant. Well, you just saw that in Marshall, it was just words that got him in contempt. But this one here, this is City of Bernalillo versus Aragon. This is made it up to the Court of Appeals of New Mexico because apparently at the municipal court, it was a municipal court. It was at a municipal court. The judge found him in contempt. He did the de novo to a district court, and the district court found him in contempt. So these are the facts that the district court relied on. A police report was generated where while leaving the courtroom, the defendant said something like, "This court sucks, and what do you have to do? Kick ass around here or what?" One witness said, while in court, the defendant stated this court sucked. The municipal judge then imposed a 10-day sentence for contempt of court. This particular witness here, Eddie Galara Jr., said at the end of the defendant's hearing in municipal court, defendant stated that court sucked. The municipal court found him in contempt. Carolyn Lee said, after the municipal judge sentenced defendant to 90 days probation, the defendant said this court sucks. When the judge asked what the defendant had said, defendant said the court sucks. The court then sentenced defendant to 10 days in jail for contempt. And then the judge's affidavit, this is the municipal court judge who found him in contempt initially. He said that the defendant made many contemptuous remarks with reference to the judicial proceedings. The judge advised the defendant not to be disrespectful to the court as the defendant could be found in contempt of court. The defendant continued to be disrespectful in many ways, including but not limited to blasphemies and obscenities directed at a affiant. That would be the judge. Defendant was ultimately found to be in contempt of court. So the end result of this was that he was found in contempt, and the contempt was the conduct of the defendant justified his contempt proceedings and his conviction by the municipal court and the affirmance of that conviction by the district judge. So for saying this court sucks, which are words, this is an actual case. This is a New Mexico Court of Appeals case. You can see it. You can see the citation. For saying this court sucks, he was found in contempt. So could Lane Myers be found in contempt for his actions in court on the day that I made that video? Lane Myers flirts with contempt. Absolutely. Absolutely he could. At this point, if he's not already been found to be in contempt by the judge would most likely have to grant him a hearing because time has elapsed. And my understanding of New Mexico law is that if time elapses, if it's not a summary procedure, I think 26 days was the case that I read, where 26 days had passed from the date of the contemptuous behavior in court and the finding by the court of criminal contempt, direct criminal contempt. That was too long, and the court had to give him a hearing at that point. So at this point, maybe he is entitled to a hearing, but it wouldn't be a full evidentiary hearing and jury trial. I believe it would still be the same judge, and I believe that so no jury trial, same judge. And I believe at this point the judge would basically just have to allow him to, has to be a hearing. I don't know. So maybe I'm getting a little off. At this point, he's entitled to a hearing for the behavior on that date. But on that date, the judge could have held him in summary contempt because obviously Rule 6-111 and the references to the various New Mexico statutes allows him to. City of Bernalillo versus Aragon allows it. Concha versus Sanchez, which is the New Mexico Supreme Court case, allows it. Matter of Marshall, which is a New Mexico Supreme Court case, allows it. It's permissible to hold people in direct contempt under United States Supreme Court law. It's not a violation of due process rights if you commit contempt in the direct side of the judge, where the judge sees you do it in court. Then that's your goal. The judge's gold at that point. So anyway, that's all I got for you today.